be helpful in helping the committee to further understand the bill and be able to deal with it in accordance with the law. Now, colleagues, you remember the other day we had the issue of time, which we have subsequently handled. The speed has since been reduced because our original plan was to have this bill presented today. But now we have up next week, so the speed has since been checked. And so for today, we'll receive the DPP and any other stakeholder who will show interest immediately after appearance of the DPP. If there is no stakeholder, we will then proceed to do clause by clause of the bill of all the other non-contentious issues, because as you realize, this bill has about 76 clauses, and about 72 of them are pretty obvious. The forces and the veterans, touching on their issues of command and control structures of the Updf. So those provisions, for me, have not attracted any contentions, and so we can proceed to consider them clause by clause. And then at 2 p.m., I've invited the Attorney General and the Minister for Defense to come such that we can now start working on the contentious clauses. We can see if we can interact with them and agree on some of the clauses. If we can be able to agree today, then we'll be done. Then we can write a report and have it ready probably by Monday. If we don't make a breakthrough in today's meeting at 2 p.m., that will take us to next week. So that is the, and with those few remarks, I also note that maybe before I invite the DPP, I note that other than myself and the General Masco, the rest of the members are not decent within the meaning of our rules. So I waive Rule 88 to cover members who are indecent. With those few remarks, I wish to invite the DPP to make his presentation. Thank you so much.
With us, she's away on official duties, and I'd like to convey her apologies to this committee, and she asked me to stand in and left me as the officer caretaking the office. So, Honorable Chairperson and members, we are here following the, maybe, Chair, for how long? How much time do we have?
We can use, how many pages do we have? 15. Yeah, you can present for 30 minutes. And then we can interact with you for another 30 minutes. I've been joined by colleagues from
honorable members, chairperson and members, we are here following your invitation dated 13th of May, 2025, thinking our views or the views of ODPP on this bill that is under consideration. We are grateful for your invitation and we wish to make the following comments. The mandate of the DPP, as established under Article 120 of the Constitution, is to direct the police to investigate any information of criminal nature, institute criminal proceedings against any person or authority in any court with competent jurisdiction other than the court-martial, and to generally conduct criminal prosecutions in all courts of judicature. As far as the DPP, we are concerned, we are one of the ultimate consumers of most of the criminal laws, except that our constitutional mandate does not extend to the conduct of criminal prosecutions in the court-martial. Honorable Chairperson and members, we agree that the bill is necessary to, among others, to give effect to the declarations and advisory orders of the Supreme Court in the Attorney General versus Michael Kawazi Guruka Constitutional Petition number 2 of 2021, which was delivered on 31st of January 2025. Following this, the Attorney General on 3rd February 2025 issued guidance on the Supreme Court judgment and advised the DPP as follows. That one appears on page 2, which I may not go through the whole of it, but it's what was contained in the advice or the letter of the Attorney General. Now, following this guidance, the DPP convened a meeting on 6th of February 2025 with the General Court Martial leadership, where it was resolved that the latter should transfer all investigative files to the civilian courts. Then on 11th of February 2025, the DPP issued a circular, that is circular number 1 of 2025, communicating to our staff, and a team was set up to handle the files, case files to be transferred from the General Court Martial. The ODPP has so far received 45 investigative files, including the file of Uganda versus Chiza Besigye and 2 others, which is already in Nakawa Chief Magistrate's Court, and the case of Uganda versus Cherimo Julius, which is already filed at the International Crimes Division of the High Court. The rest of the files were sent to the CID for further investigations. The judgment of the Supreme Court had declarations and orders and advisory orders. On page 3, we reproduce the declarations that appear in the judgment of the Supreme Court. And on page 4, the line by line. Okay. It's very important. Okay. The declarations, that is on page 3, Chair. The Summary Trial Authority and the Unit Disciplinary Committee are respectively lawfully established under Section 189 and 190 and Section 193 of the UPDF Act as military tribunals. 2, the provision of Section 195 of the UPDF Act establishing the General Court Martial as a competent court is constitutional. 3, the General Court Martial created under Section 195 of the UPDF Act is a subordinate court of law, but with specialized jurisdiction. The provisions of Section 177, 1 and 2 of the UPDF Act, read together with Section 195.2, which grant subordinate military court jurisdiction over capital offenses, contravene Article 129(1)(d) and Article 126(1) of the Constitution, hence they are unconstitutional. The provisions of Section 189(3)(a) and Section 193(3) 3 and 4, read together with Section 177 of the UPDF Act, which grant the STA and UDC, that is the Unity Disciplinary Committee, the exercise of judicial powers of detention and imprisonment of any person tried by them, contravene Article 23, 126(1) and 129(1)(d) of the Constitution, hence they are unconstitutional. The provisions of the UPDF Act constituting and providing for the trial procedure of the General Court Martial, the Division Court Martial, and the Court Martial Appeal Court do not contain any or sufficient constitutional guarantees and safeguards for them to exercise their judicial functions with independence and impartiality, which is a prerequisite for fair hearing provided under Article 21, 28, 1, 44C, and 128(1) of the Constitution. The provision of section 1171G of the Updf Act, under which the respondent, a civilian, was charged and arraigned in the General Court Martial, contravenes Article 28(1), 44C, and 121 of the Constitution. Hence, it is unconstitutional. The provision of section 1171G is unconstitutional to the extent that it permits trial in the court martial of civilians who have allegedly aided and abetted the commission of a service offense or ordinary criminal offense in which a person subject to military law is a principal offender. Section 1177, 1171H and G of the Updf Act are unconstitutional since they confer blanket jurisdiction on courts on martial to try civilians. The jurisdiction conferred by Section 1, Section 10, Section 177, and Section 1171H of the Updf Act on the General Court Martial to try persons subject to military law for civil and or non-disciplinary offenses committed in Uganda are unconstitutional as they contravene Article 209 and 210 of the Constitution. Those were the declarations that picked from the judgment. Then the orders, not otherwise subject to military law, who aids and abets a person subject to military law in the commission of service of offense is constitutional, is unconstitutional, and is hereby set aside. Sorry about that. Is constitutional and is hereby set aside. 2, all charges or ongoing trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and the sentence is being challenged in a court of law. 4, all pending trials or partly heard criminal cases that fall under the civil law court's jurisdiction, which are against members of the Updf who are subject to service law, must be transferred to the civil courts with competent jurisdiction. Those were the orders. Now, the court also made advisory orders and a recommendation to the executive and the parliament for consideration as viable alternatives for the establishment and or creation of a military courts in Uganda. The first one was that administratively establish the General Court Martial as a division of the High Court without the need to create a new court with jurisdiction to handle capital criminal cases involving both military officers and any civilian who would exceptionally fall within its ambit, with magistrates within the division handling offenses falling under their jurisdiction. B, limit functions of the Unit Disciplinary Committee and summary trial authorities to handling strictly disciplinary offenses with no powers of imposing sentences of imprisonment. C, utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offenses committed in Uganda, which are currently falling within the docket of the UDCs. The subordinate military courts can handle criminal cases at the level of the Chief Magistrate's Court for offenses attracting imprisonment, life imprisonment and below. Or, with the advice of the Judicial Service Commission, appoint civilians with requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. They would exercise jurisdiction over offenses triable by subordinate courts. they should have the same privileges and safeguards as their counterparts in the civil courts. Or amend the Constitution to establish superior courts within military court system under Article 129 and close them with requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses of a capital nature and all other offenses under existing laws committed by military personnel. Or provide in the Updf Act for the High Court to sit as a court-martial with powers to try all criminal capital offenses within the High Court's jurisdiction and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format with the Court of Appeal sitting as such. Magistrate courts would assume the jurisdiction over all offenses of a subordinate court. Make provision in the Updf Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court should come. Okay, I've read it. Sorry, I've not read it correctly, but demonstrated to court by verifiable facts and by objective and serious reasons that the need and justification that we should recourse to the military court. This must only apply where, in relation to the specific classes or category of persons or offenses in question, ordinary courts are not in a position to undertake such trials. Make provision in the Updf Act for appeal from military courts and tribunals corresponding to appeals in the ordinary courts. In each of the options suggested above, the jurisdiction of UDCs and STAs must be limited to that of tribunals handling strictly disciplinary offenses with no power of detention or imprisonment, as in the case with other disciplinary forces such as the police and prisons. Now we go to the specific comments that we have come up with. As the provision would mean that the General Court-Martial can even try corruption-related offenses under the Anti-Corruption Act, reserved for the Anti-Corruption Division of the High Court, war crimes, crimes against humanity under the ICC Act, terrorism under the Anti-Terrorism Act, reserved for the International Crimes Division of the High Court, and others. Some of these laws require specialized skills that are acquired over time. Section 202B5 specifically defines the head of the prosecuting authority of the General Court-Martial as opposed to the general referenced prosecutors under Section 202B1D. The qualifications of the prosecutors and their terms of service should also be stated. Please also note that subsection 2 was omitted in the bill. Here, Chair, we trying to explain that whereas we are providing for members of the General Court-Martial, the issue of prosecutors who are supposed to handle those cases, their qualifications, their appointment is not being catered for. And there is also a provision that these appeals will go to Court of Appeal. So who will be the prosecutors to prosecute these cases in case they go to Court of Appeal? We think that the people who are prosecuting these cases in the court-martial should have the necessary qualifications so that if the appeals come up, then they continue to prosecute them in the Court of Appeals and so on. Because previously, we have faced a situation where cases from the General Court Martial went to Court of Appeal, and the office of the DPP was summoned, I would say, to come and prosecute. And for us, we found it very difficult to handle such cases, which we did not prosecute in the first instance. So this one should be clear. It should come out very, very clear. Amend Section 209 of the Principal Act. Our response, under Section 207 of the Principal Act, it is provided that the rules of evidence and procedures to be observed in the proceedings before the General Court Martial shall, as far as is practicable, be the same as those observed in the proceedings before civil courts. These provisions appear to create room for limitations to the rules of natural justice applicable to criminal trials in the General Court Martial. This will contravene Article 21 of the Constitution, which provides for equality before the law, as well as Article 28 of the Constitution on a fair hearing. We recommend that the provisions should require that the rules of evidence and procedure applicable in civil courts shall apply to the trials before the General Court Martial without any limitations. Clause 57 of the bill is intended to amend Section 225 of the Principal Act. Our response is that under 225(2), it is provided that subsection 1 shall not affect the operation of any sentence imposed by a court martial other than a sentence of death imposed by the General Court Martial. This provision is redundant, as it is obvious that any sentence or order of court remains operational unless and until the same is overturned by competent court. We recommend that to avoid confusion of misinterpreting the provision, the same should be deleted or repealed from the Principal Act. Next. Under subsection 225(3), it is proposed that where a sentence of death is imposed by the General Court Martial, the sentence shall not be executed until after the expiry of the time within which notice of intention to appeal against the conviction may be given, and if notice of intention to appeal is may be given, and if notice of intention to appeal is duly given, the sentence shall not be executed until the appeal has been determined or abandoned. A response is that the use of the phrase notice of intention to appeal does not represent an actual notice of appeal as provided under Section 227(1) of the Principal Act. Second, the provision creates room for execution of a death sentence for persons who have not appealed before such sentences are reviewed by the highest appellate court of the land, and this contravenes the provisions of Article 22(1) of the Constitution. This article provides that no person shall be deprived of his life intentionally except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of a criminal offense under the laws of Uganda, and the conviction and the sentence have been confirmed by the highest appellate court. The above provision creates an automatic appeal against any conviction and sentence of death. Execution of the death sentence can never be constitutionally carried out unless it has been confirmed by the Supreme Court, regardless of whether or not the convict lodged an appeal. We recommend, our recommendation is that align the provision of in section 2273 of the Principal Act in clause 57 of the bill with the dictates of Article 221 of the Constitution. Chair, on page 14, we also make other recommendations as follows. Clause 1, there should be a definition of a court to cover all the proposed appellate court processes at Court of Appeal and the Supreme Court. Clause 35, which deals with the tenure of the chairperson of UCM under Section 192.10, Section 193.4, and Section 195.4 provide for a 3-year renewable term of office. This goes against the tenets of independence of judicial officers as espoused under the Constitution. There should be a security of tenure. 3 years is a very short time and may be declared unconstitutional. And the case in point is that constitutional petition number 33 of 2016, Justice Asaf Ruhinda-Ntenje and another versus the Attorney General, where the Constitutional Court held that limiting the tenure of industrial court judges to a fixed term contract of 5 years, as previously provided by the Labor Disputes Act, was unconstitutional. Still under Clause 35, Section 192.15 of the bill, is proposed to provide that the Court of Appeal shall be the final court for the appeal arising from the decisions of a unit court-martial. This provision limits the right of appeal. Under the bill, decisions of the unit court-martial and the division court-martial lie to the general court-martial as first appeals. This means that their second appeal are to the Court of Appeal. A person aggrieved by the decision of the second appeal has a right to a third appeal on a question of law in a civilian court or in a civilian courts. This would give a room for an appeal to the Supreme Court. We therefore recommend that Section 192.15 be revised to allow a third appeal to the Supreme Court from the decision of the Court of Appeal on matters that originated from a unit and divisional court-martial only on the questions of law. Finally, we also recommend that the bill should have a transitional provision to address the status of cases affected by the ruling in the Kabazuka's petition. As noted in our preamble, some cases have been transferred to DPP's, for DPP's action. Some of the cases may be still at the General Court-Martial. Therefore, if the bill is passed, will it have a retrospective effect? How should it apply to cases affected by the Supreme Court decision? As we conclude, Chair, we support the bill to give effect to the judgment of the Supreme Court. However, the above comments, observations, and recommendations should be considered to ensure effective administration of justice. Thank you. I submit, Chair.
Suggest that giving 3 years could easily be declared unconstitutional. Maybe, I don't know, but in my legal knowledge, I don't know whether there's any specific term of office prescribed in any provision of the Constitution to make 3 years unconstitutional. I want them to throw a little bit of more light. Other than the ruling which they relied on, is there a specific provision that make it authoritative that if you have 3 terms or more, it can be unconstitutional? Maybe I just wanted to. We're suspicious. We're just suspicious.
No, the ruling is itself authoritative. The one of Asaf.
But it was not about the 3 years or 5 years. You see, the manner in which it came, the ruling, the manner in which it. That's what I wanted.
You know, the years touch on the 10-year touches on the independence and the.
Excuse me, sir.
But
if you are not independent in 1 year, you cannot be independent in 5 years. What shows that many years can make you independent?
Okay.
I mean,
The
I want to
DPP
know
will
the number of
respond.
years and independence. How does it affect independence? The number of years? I want just to know, generally.
Security of tenure.
But even 3 years, you are very secure. You are secure for 3 years. I mean,
Okay, thank you. Any other matter?
Act for trial of civilians in military courts to be only under limited circumstances, and only the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. And this must only apply where in relation to the specific class or category of persons and offences in question ordinary courts. Now, I am seeking your additional guidance on the process of verification. What in the circumstances would you recommend to be the verification process to come to this conclusion? The verification process, in my fear, is that it may become a trial within a trial itself. And I seek your guidance on that. Thank you.
Honorable Jonathan Adur.
Thank you, Chair, and thank you, Deputy DPP, and asking this, referring to the offense of murder, for example. Is there another definition of murder under the military law?
If Uganda is not a communist state like Cuba, North Korea, and others, why would the executive or the president be pushing civilians to be tried in military courts?
Would you help me to know whether, studying from the standard running of militaries universally, this law offends that universality?
In the Updf Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reason the need and justification of recourse to the military court. In our preamble, some cases have been transferred for DPP's action. Some cases may still be at the GCM. Therefore, if this bill is passed, will it have retrospective effect? You have pushed it to us, and so it would push this to you. How should it apply to cases affected by the Supreme Court decisions? We want to ask you the same question. You know, you are now our technical advisors. Just assuming all of us here are not lawyers. For us, we are now politicians. Don't say, oh, there is a lawyer here, there is no. You are the technical people supposed to advise us technically. So now, when you ask this question to politicians and you are lawyers, I think I find that a little bit interesting. Because you should be providing answers to us. So just assuming there is no lawyer this side, you are the lawyers only, very brilliant lawyers. So give us answers to this question you've asked. Because we will not provide the answers, because these are technical questions, Mr. Chairman. Yes, and a technical person should not ask a politician a technical question. Instead, he should provide answers to it. But at the end, I would like to thank them really for the short time they've had. They have done quite incredible work. Thank you very much.
Followed by.
This means if a civilian committed an offense, they have got to first be tried in the civil court and then recommended to the general court martial?
The MP from Kono municipality, I'm also the shadow minister. We recommend that the provision should require that the rules of evidence and procedure applicable in civil courts shall apply to trials before the general court martial without any limitations. So for what purpose are we setting up courts when they are going to operate under the very same provisions as the normal courts are operating. So for what purpose are we setting up these ones? Why are we duplicating laws? Because you are setting up a court, a new system, but you are saying that it should operate as if it were the other court. So for what purpose are we setting up these? What makes them special? Why should we spend taxpayers' money on a system that is going to do exactly the same thing as the other formal courts are doing? So I want to be clarified on that, Mr. Speaker. Or maybe one time you will be anyway. Inshallah. Mr. Chairman.
No, Nyambo is only used to addressing speakers.
No.
Not common men.
Thank you, Mr. Chairman, for now.
Yes.
Mr. Chairman, you should protect me from Honorable this one.
But there is what there is the law principle of
Letting me greatly here, Mr. Chairman, protect me.
Do you know about a principle?
He wants to
called
fox me.
Volunteer. You have voluntarily assumed the risk by sitting near.
You know, this is a very important office in regard to prosecution, but I just have a simple general court martial should be restricted to only offenses under the UPDF Act.
Mr. Chairman, I was not going to contribute, but I want for a well-written document and advice to this group, to this committee. My bill is, for example, the question of I support the bill in main parts, but one thing which excites me in being part of this committee is what they have captured on page 12, 4.4, clause 4.4, and especially emphasizing that the provisions of what we are going to do, the law we are going to make, should require that the rules of evidence and procedure applicable in civilian courts should apply to those before the court martial. And I say this with a lot of pain because as we talk now, across Karamoja, there are over 3,500 young men that went through the hands of the unit disciplinary courts, general court, third division court martial. Quite a number of them, not all, quite a number of them were caught. Maybe in a session, a friend had a gun, then he said we had together with so and so. So you find some of them were sentenced on the basis of one gun to 23 years. 2 weeks ago, I visited them in Kitalia. If you visited Kitalia, there is a population of 2,981 persons. Out of those 2,981, those from my constituency are 972. Big population. And some of them are serving 20 years, 30 years. I had the opportunity to take some of their wives and their mothers. Some of them cried and said, "Mother, I know I will not be able to see you." Because I said, I asked them, some of them, honestly, you are here now. What did you do? He said, "Honorable, the gun was with so-and-so. 20 of us were sentenced. It was like a mass sentence. The rules of evidence are the weakest in a military court. What do you expect that the soldier, some of these young men, warriors, they engage military, they engage soldiers. And the process, some of them, the soldiers get killed, the warriors also get killed. So when they are rounded up, and this is what happens in the cordon and such, soldiers are also angry because these warriors one of them has killed them, and they have entered this manyatta. So they round a manyatta. It doesn't matter who really had a gun. So you find one gun, 30 people are sentenced to 30 years each. It's like this, how some of our Christians in Pentecostal in these churches have a wedding. They have a mass wedding. Yeah. I have seen one in South Africa where one man was marrying 30 women. But in Uganda, yeah, I saw in a picture where all of you pronounce, you are 100 couples, and you just pronounce, I don't know who's vows the God has had. So in Karamoja, we get mass sentences. Young men get mass sentences. The weakest link is, first of all, the rules of evidence. Number two is anger, motion, subjectivity. You don't expect justice from the guy who is injured. And thirdly, a number of the members of the General Court Martial. There's only one prosecutor. And recently, in my constituency, a lot of them had stayed for almost 3-4 months without a prosecutor. And I asked them, why are you keeping this young man here for 3 months without even trial in the court martial? They say the prosecutor is in Kaweta for training. So if you want, you get a car, we go and pick him and take him tomorrow to prosecute. And he comes there at night and says, all of you are guilty, go, 2030. It was because of this that saved a lot of men. So I am happy that this committee, of which I'm a member, that we make, I wish we could make this law be not just by sitting here, first by visiting and listening to some of these people in these prisons that have passed through the General Court Martial or through the Division Court Martials. It would be important, Mr. Chairman, that this committee doesn't process this bill before visiting even Kitalia and listen to them. Those that have been sentenced, how did they go? What was who was even the prosecutor? And you go to the court martial, who are the members? I know one of the members of the court martial in Moroto was with me in high school. He didn't even finish his senior 5, and he has never seen any court. So that's the people who sentence other people, including you. If you are caught, Mr. Chairman Baka, if we suspect you have a gun or you are putting on something green, we can take you there and you serve a very nice sentence of 20 years for appearing to be dressed like a general, my general brother here. So it is a pain, and I think we need to have this, to organize it as the court has directed, that whoever it is, and I like the second one, where the offender commits an offense beyond those provided under the Updf Act, jurisdiction will be vested in the applicable civil court. That's so important. Yeah. If why we should be able to filter out. Why should we push you to military when you could be in the civilian court? Or if the rules of equality provide, why should rank matter in a court martial? Then maybe my brother can explain. You're an offender, and you must be equalized before the law. So some of these things, I think, to provide, and I like tenure should be like as much as possible with like the one in the ordinary courts, in the courts here. But the center of gravity is qualifications, the rules of evidence, and this impartiality, especially in this court martial. If we get this right, I think we would be comfortable. Thank you.
Can you tell us about the impact on the ground? We have heard from Honorable Chero telling us that
now I am actually
Karamoja is now quiet because of the General Court Martial. The general good. Tell us about that.
A lot of things, the dynamics have changed. Obviously, the UPDF and the other security forces have done quite a significant role, and the local leaders to disarm the population. You can't believe it. A population of Karamoja were about less than 1 million people, but they had guns, was almost more than 50,000, and that's the size of our army, AK-47. Equivalent to the army in Uganda, 50,000. Those are even more guns. So to remove those guns in almost every hand, really, I think it's one of the best policy that the NRM has done in Karamoja, to remove guns. Because they were like walking sticks. And they were so dangerous, even to kill, by mistake, to kill even the owners when they would get drunk. So peace has returned. A number of things have happened. I can tell you, one of them is we stopped the Kenyans, the Turkana, from entering into Uganda with guns. The guns have been cleaned up in Uganda. There's a lot of participation by the local leaders in removing these guns. Yes, some of the criminals, also among the groups that have been arrested, were really notorious, That's why I'm saying not all of them. They were really notorious ones and they are prison, rightly so, and even the local leaders. We were witnesses in some of the courts that they should be kept away. But in other areas, situations, most of them are taken. So that's one part. The second impact has been these thousands. Some of them have left families behind. And because when they go there, they've gone for 20, 30 years, their wives have remarried. And recently we appealed to the president to give amnesty to some of these young people. And the UPDF went to do the filtering exercise, and we are hoping that some of them will be released. But it will need kind of counseling, because those other relatives who remain behind, some of them have sold their livestock. They have disposed of their assets. So they will go to a situation where the wife has remarried, your cows have been sold, and they might restart challenges. So we are negotiating a situation where we can also help them to probably do the way we did it with the West Nile Bank front. Give some packages, amnesty plus a package that can help them to settle down. Yes.
We can now have the honorable member for Wekula and then honorable.
One is, I'm 7 not Timagurwa. Chair, I want to thank the office of the DPP, but I expected them to share with us some experience where they have got challenges because they are court users in prosecution, and they have felt that their work and they intend and they think with this bill, those challenges are going to be addressed. Because I need to know from them whether somewhere, when doing their work, they have found the challenges. And these challenges can only be addressed by this bill, or they are addressed in this bill. They think this bill can address them, because you are court users. With the creation of this general court martial, what challenges are going to be addressed? And you have been experiencing them during your work. Thank you.
As a worker, election of members of parliament for workers is considered as people who are marginalized. And it's the reason why we use trade unions as a college. At one stage, members went to court, and court pronounced that the elections of workers shall not only be done by trade unions, but shall also include non-unionized. Up to now, Parliament has been tried to change this, but Parliament says this court's pronouncement we cannot change. How is it different from this UPDF, where the Supreme Court has made pronouncements and you technical people are just trying to alter? I thought these rulings, these directives that has been made forms just part and parcel of this act. And I need that guidance from you, the technical people. How is it different from the other one of non-unionized compared to this one? I thank you.
Thank you. Listen now.
That those exceptional circumstances should be restricted to offenses under the UPDF Act. Otherwise, if you provided that they can have powers to preside offenses in any other law that this parliament makes, first you will be creating a contradiction. It will be some sort of vote of no confidence from the civil system for which the military is subordinate.
The General Court Martial, where it is stated that it is proposed that the General Court Martial should have unlimited original jurisdiction to try offenses under the UPDF Act and under any other written law committed by a person subject to military law. Yes. So we had here, I think it was either the Attorney General or the Minister, justifying this provision to say that, for example, if there is an operation in the Congo or in Somalia, and a member of the UPDF subject to military law commits an offense there, either rape or robbery, they are tried, for example, under the laws of that country, but by the General Court Martial here, something like that. Because if you restrict them to only the UPDF Act, how will they be able to try officers who commit offenses all over the place? So
we will supplement if my opinion doesn't tally well. If that is to relate to serving officers, then the law needs to be clear. That the court martial can apply other laws for offenses that may not be in the UPDF Act if those offenses have been committed by officers in service. You know? Yes, outside the country. Yes. Now, coming to what Honorable Abudu Katuntu commented. Actually, your worry, we have catered for it. If you read our page 6, our page 12, that particular provision, we, in our view, found it redundant and unnecessary. And we recommended that to avoid, well, page 13, from 12 to 13, that particular provision that you were raising, 225 subsection 2, is redundant and confusing. And in our view, it should be just removed, because it is common knowledge that if there is an order given by a court, that order will stand until otherwise changed or reversed. And then finally, the worry by Honorable Nyeko as to whether the court martial will not be used as a whipping stick. We can only avoid that if we provide for the necessary safeguards. Because even our court system can be misused. But the only reason it is difficult for somebody to misuse the civil system is because they are clear safeguards in place. And those safeguards, we have proposed them here, you know, give security of tenure, the appointment process, because look at the language being used in this act, that the High Command will recommend in consultation. What does consultation with Judicial Service Commission mean? There is no role by Judicial Service Commission. Does consultation mean vetting? I don't think so. So you can see the proposal we are saying that they can generate lists, recommend them, and then the Judicial Service Commission does the vetting and onward submission for appointment to the President. The very way our judges go through. And very finally, sir, it appears that most people think that there are certain circumstances that court martials will serve the purpose which ordinary courts may not serve. And the reason they think so is because of the weaknesses or loopholes in our civil systems. So other than committing a risk of doing something that will attract subsequent legislation, we should also look at how we should empower and address the things that are making the ordinary court systems not to work, so that we empower them to serve the purpose. Thank you so much. Deputy is asking me to comment about those proof of exceptional circumstances. It is going to be very difficult to demonstrate that, for example, the Office of the National Prosecutor doesn't have the capacity to prosecute any case. It is very unlikely that anybody would have the capacity to demonstrate. Or that our judges in the civil system have no capacity to try any offense, and that capacity is only in the military, it's going to be very difficult to justify. The only way we can be understood and appreciated that the circumstances are justifiable is only if we provide that only offenses in the UPDF Act, so that we have a general legal justification. But I don't see how you are going to justify that the civil systems don't have capacity to do things which the military has capacity to do.
Mr. Chairman, I just want to chip in here in discussing with because of your unique situations. And in the case of Karamoja, what has happened historically? The governments were overthrown, Moroto division was broken, Karamojong got access to AK-47s, they continued to buy from Sudan. What is unique in Karamoja is civilians having guns, running around lawlessly without any command, and sometimes taking the law into their own hands, mostly because of absence of the state. Until recently, I didn't have even police in some of my sub-counties. I remember the other year when I introduced police in one of the sub-counties in Atirai, the civilians were asking, what's the use of these people? They know the role of the UPDF, but what are these people? It was difficult even for me to say, keep law and order, but they have kept law and order, they have their own courts. So what would be the unique circumstances that I can say, in the case of Karamoja, warrant the Karamoja young men to be prosecuted? And maybe, this is rhetorical, but maybe my brother General Maziko has some of them in his mind. So that I could also be clear why we would continue to be under the division court martial.
The issue of universality of military courts, however, taking into account the extent, what would be your view about the issue of the uniqueness of the historical circumstances of a country? Is it anything to think about by ourselves?
Misunderstand his question.
For example, you said what Uganda has gone through and what Kenya has been. So would it be out of place?
But Chair.
Yes. What's the point of order? What was it about?
No, in respect so much as an ideologue who was stationed in Nali, Chankwanzi, and had all the opportunity to teach those historical...
We cannot live in total denial of where we have come from and where we are. But as we speak now, one of the prominent leaders of a prolonged rebellion in this country, Jamiru Mukuru, is undergoing trial in the civil courts. Not necessarily the court martial. So, if provision is made in the right court for the right offenses, what matters is that there should be a proper system that is fair and adequate to render justice. And in this case, we have amplified the need for the continuation of the general court martial, only that we have said that it should not have universal application. We would be causing a big problem in our humble view. But if you removed the general court martial from their role of enforcing military discipline, you will also have chaos in the country. So you need it, but only in specific circumstances. And that's what we are trying to say here.
Mr. DP Namboze, the guidance from the Attorney General that we referred to. For clarity, the leaders of the court and how we should proceed. And actually, it was not addressed to us alone. He addressed several government
institutions which had something to do with this judgment, including UPDF. And we took up the guidance, we picked the judgment, and also read it on our own, and that's why we have been able to put up this response, because we know our obligations. The honorable members also wondered whether DPP, whether us supporting this bill is not a contradiction of the orders of the judgment of the Supreme Court. We are here to ensure that there is no contradiction. That's why we are responding to some of these provisions and giving in our proposals so that we keep in line with what the Supreme Court decided. On the cases transferred from UPDF, Honorable Nyoko wanted us to tell you the numbers. We are only able to know the numbers that have come to us. We cannot go into UPDF and all the court martials and know how many cases they have. Yes, we don't have that mandate in the Constitution. We are only at the waiting end. If they have more cases, we are sure they will bring them. Yes. So I think...
which specifically handles cases that fall under the Anti-Corruption Act. So, equally, in our view, the law that gives jurisdiction or powers to the General Court Martial should be very specific as to the offenses that are supposed to be handled by that General Court Martial, not just other offenses. That's one. Then two, of course, once the offenses are committed, like somebody who commits a corruption offense in any part of the country, we know that this one falls under this division. So it's like, it will be like another specialized court, but which must have all what it takes to ensure a fair trial. Two, of course, it does not mean that ODPP does not have capacity to prosecute these offenses. We do have the capacity, and once, of course, we have the capacity, but only in civilian courts. But we have the capacity to prosecute these offenses. These are ordinary offenses of murder, aggravated robbery, and so on. Then, of course, one of the members asked if everything is provided. Will there be a delay? No. If everything is provided, we will be moving on. Well, we shall handle the cases and prosecute them in time. Then the questions which we raised about, which appear on page 15, these are questions which the law should be clear and cover. It shouldn't really leave a room for somebody to start wondering what is going to happen when the law is passed. These are questions or areas that should adequately be covered in the transition, in that provision which we have pointed out. Otherwise, we thank you, Chairperson and honorable members, for this opportunity that has been afforded to us as the Office of the DPP, and we are looking forward, of course, to render the services that we are mandated to render as Office of the DPP, independently, in impartial manner, without fear and favor. I thank you.
And it was agreed upon. So now the guidance I'm seeking is what happens to that resolution. I know you are the chair here and my chair is your vice. And I know now that we have now combined the forces. We are the same parliament, and it was not out of nothing that we made that resolution. It was upon a very big background. So, Mr. Chairman, I'm seeking for guidance as a way of procedure on how we proceed in relation to resolutions that we had already made separately. Thank you.
Honorable Chair, before you guide the Honorable, just for purposes of record,
the Uganda People's Defense Forces Amendment Bill 2025, gazetted on 2nd May 2025, has never been a subject of discussion in the Defense and Internal Affairs Committee. So I don't know what Honorable Namboze is talking about. She may perhaps need to restate her case and present facts that are tenable. Our concern is on a wrong premise.
Chairman.
Chair.
The guidance I should give because
Chairman.
Chair, before guidance.
Excuse me, Mr. Chairman.
I can see all members of defense. Yes, Deputy Defense. Deputy Defense, what are you saying?
Chair, thank you so much. Matters of defense